Whoa. It moved on me there. Apologize for that. Committee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Examining the Current Data Security and Breach Notification Regulatory Regime. Before we begin, I'd like to thank the witnesses for appearing before the subcommittee. We appreciate your participation and look forward to today's discussion. And I recognize myself for 3 minutes for the purpose of delivering an opening statement. Every year, the number and severity of data breaches seems to increase, and more Americans seem to become victims of fraud and identity theft. Consumers are left not only facing financial harm, but also the daunting task of restoring the integrity of their personal information. With constant technological advancements come more sophisticated threats to data security. Some of the largest financial institutions in the United States deal with hundreds, if not thousands, of cyber threats on a daily basis. Those attacks aren't just from one-off hackers, but sometimes highly organized criminal enterprises backed by foreign nation states. The majority of entities that handle personally identifiable information work hard to protect it from fraudulent acquisition and use. As we consider reform of the current regulatory regime surrounding data security standards and notification requirements, we should bear in mind that in many instances, it's both the entity and the consumer that's been the victim of the crime. While I recognize that companies work hard to guard against complex threats, it's sometimes the smallest and most avoidable errors that lead to the largest breaches. A company only has to be wrong once. The 2017 Equifax breach is a textbook example of the importance of good data security hygiene. This is a vastly complex issue that impacts nearly every business in this nation, but our primary focus throughout this endeavor should be the consumer. Can we create a system that puts them first? How can we safeguard their data without overburdening the entities that they patronize? When is the right time to notify them that a breach may have occurred? Bottom line is that we, the American people, deserve better than the status quo. All entities that handle our personal information have some responsibility to maintain data security standards that protect our information and to keep us better informed of instances that could lead to theft, fraud, or economic loss. We have the right to this information so we can be empowered to protect ourselves. Today's hearing will provide the committee with an opportunity to hear from witnesses with diverse professional backgrounds and opinions on data security. I want to thank them for offering their perspectives today. We look forward to your testimony and to continued collaboration on this incredibly important issue. The chair now recognizes the ranking member of the subcommittee, another gentleman from Missouri, Mr. Clay, for 5 minutes for an opening statement.
Thank you, Mr. Chair. At this time, I will forego the opening statement, and hopefully we can get to the witnesses. I yield back.
Mr. Rosas? We are done with opening statements. You guys are lucky this morning. With that, we welcome testimony of our witnesses, and a number of you have got names that are like Luke to mine, a little difficult to pronounce, and I apologize if I get them wrong this morning, but Mr. Aaron Cooper, Vice President for Global Policy, BSA, the Software Alliance. Ms. Kim Sponham, President and CEO, Summit Credit Union on behalf of the Credit Union National Association. Mr. Nathan Tailor, Partner, Morrison & Forrester, LLP. Professor Mac Rottenberg, is that right, or Rotenberg? Mark Rotenberg, President, Electronic Privacy Information Center and Adjunct Professor, Georgetown University Law Center. And Mr. Paul Rosenweig, pretty close?
Much better than most, sir.
Okay. See, obviously we're not right yet, that's the problem, but that's okay. Appreciate your diligence. Senior Fellow, Law Street Institute. Each of you will be recognized for 5 minutes to give an oral presentation or testimony without objection. Each of your written statements will be made part of the record. Just a little tutorial on the lighting system in front of you. Green means go. When you see a yellow button pop up there, that means you got 1 minute to wrap up, and red means stop. I have a gavel up here that we will make that emphatically known if we need to. I would ask that you pull the microphones close to you. They do move. They're not stationary on the desk there. You can pull them toward you so we can hear you. Sometimes if you speak softly, it's a little difficult in this large room to get the right acoustics. So with that, Mr. Cooper, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Good morning, Chairman Lukemeyer, Ranking Member Clay, and members of the subcommittee. My name is Aaron Cooper, and I am Vice President for Global Policy at BSA, the Software Alliance. BSA is the leading advocate for the global software industry in the United States and around the world. Our members are at the forefront of cutting-edge, cloud-enabled data services that have a significant impact on U.S. job creation and the global economy. Data security is crucial to our members and to their customers in every industry sector. I commend the subcommittee for holding this hearing on such an important topic, and I thank you for the opportunity to testify. BSA's support for data security and breach notification legislation dates back more than a decade. Persistent, high-profile security incidents make the need for thoughtful legislation more important now than ever. Our economy today and economic growth and job creation in the foreseeable future is rooted in digital data. Every industry today is improved through the use of software to store, transfer, and analyze data. But the embrace of the digital economy cannot be taken for granted. If customers do not trust that their data will be kept secure, they will not use the technology. Our companies compete on privacy and security. Their customers rightfully demand it. Data breaches erode that trust in digital services and can have a significant cost on the economy. The security threats we face today are global, the adversaries increasingly sophisticated, and the motivations far more complicated than in the past. Malicious actors use both internal and external threats to commit financially motivated crimes and other forms of espionage. In some cases, advanced persistent threats are conducted by well-resourced teams of specialists that are often linked to nation-state actors. Organizations that hold sensitive data need to incorporate high standards of risk management. This does not always require adopting excessively costly or cumbersome security measures. In fact, reasonable diligence can make a considerable dent in the problem. Experts suggest that more than 90% of data breaches could be preventable through basic cyber hygiene. Compromised or weak user credentials account for the vast majority of hacking-related breaches, and patched software could prevent nearly 80% of security incidents. BSA is committed to being part of the solution, and along with our members, is leading on several important efforts. First, BSA recently released a new cybersecurity policy agenda, which addresses the need to promote a secure software ecosystem, develop a 21st century cyber workforce, and embrace emerging technologies. Second, BSA members have been leading advocates of security by design principles and secure development lifecycle approaches to developing software. Third, the industry has developed and deployed layered defenses, from protection at the data and document level to the network and perimeter level. Fourth, the use of cloud-based services offer an important option for data security. Just as a bank can better protect individual financial assets of its patrons, cloud service providers can provide a level of protection for their customers' digital assets beyond what many small and medium-sized businesses can do on their own. It is important to remember that even when customer data is placed in a cloud infrastructure, security remains a shared responsibility. Cloud providers can help reduce the operational burden associated with securing data, but security is a process, not an end state. The cloud provider and customer both have responsibilities for managing the security of data. While the industry is taking important steps, only Congress can ensure that there is a uniform and effective federal standard. In BSA's view, legislation should aim to achieve three goals. First, legislation should minimize the risk of data breaches. It should require companies that collect or maintain sensitive personal information to implement reasonable data security practices. The practices should be scoped and sized to the complexity, sensitivity, and volume of personal information on a company's systems. Second, legislation should mitigate the impact of breaches that do occur. Legislation should ensure that consumers receive timely and meaningful notification based on a risk-based analysis. Third, legislation should create uniformity. We currently have a thicket of 48 different state data breach notification standards. The variation between the state laws are not trivial, and it's unhelpful in the wake of a breach of personal information to have a company working with a team of lawyers to understand what requirements must be met in each jurisdiction before notifying customers of the breach. In conclusion, there's a lot that Congress can do to improve the situation for both businesses and consumers. Well-crafted legislation can facilitate rapid and robust responses to significant security incidents, and federal guidance on data security will drive stronger security measures across the internet ecosystem. BSA strongly supports these goals, and we look forward to working with the subcommittee to achieve them. Thank you, and I look forward to your questions.
Thank you, Mr. Cooper. Ms. Smonum, recognized for 5 minutes. Please turn your microphone on and pull it close. Thank you.
Chairman Lukemeyer, Ranking Member Clay, members of the subcommittee, Thank you for the opportunity to testify on this extremely important topic. My name is Kim Spanum, and I am Chief Executive Officer and President at Summit Credit Union, testifying on behalf of the Credit Union National Association. Summit Credit Union, headquartered in Madison, Wisconsin, is a state-chartered credit union founded in 1935. We have $3 billion in assets and serve 175,000 members, which is quite small compared to regional and national banks. Like all credit unions, we are a not-for-profit institution owned by the very members we serve. Summit Credit Union offers a full array of financial services to meet the needs of our members, including debit and credit cards. Unfortunately, data breaches occur far too often. Consumers and financial institutions are harmed by data breaches when entities and organizations, including merchants, fail to take necessary steps to protect consumer data. Community financial institutions foot the bill when companies fail to secure customer information, when many do not need to store that information in the first place. Breaches cost Summit Credit Union over $1 million in 2017 alone. But more importantly, the negative impact on consumers is significant and sometimes devastating. Imagine you are making a purchase and your card is declined. You don't know why. There is a line behind you. You are embarrassed and concerned. You figure out a different way to pay, or you walk away angry. You call your financial institution. There are fraudulent charges on your card. You now know why the purchase was declined because of fraud, but now you have the stress of wondering just what information did the fraudsters gain on you? Or you're using your debit card in another country to get currency. It is shut down. Now what do? You are worried someone is depleting your checking account. How long will it take to get that resolved? How will you get your money in another country? Panic sets in. Even worse, someone stole your identity and took out a loan in your name. Now your credit is compromised. How do you get it back? It can take years and tens of thousands of dollars to rectify. Meanwhile, my credit union is working hard to get you another card at $3 to $5 per card, overnighting them when needed at our expense. We work with you to address the fraudulent charges that are on your card that we pay for. We look to increase our fraud monitoring systems that are expensive and labor-intensive. And most of all, we spend the much-needed time with our members to help them navigate the financial system. Once you have new cards, then remembering to update your automatic payments is the next step. If you forget, you now are delinquent with that company. All fraud and fraud mediation is paid for by financial institutions. There's no incentive for companies that hold personal information to protect it, and that is just plain wrong. Under current law, credit unions and banks are subject to data security requirements, necessitating the development of procedures and systems to protect consumer information from theft, including notifying consumers in the event of a data breach. However, other entities that hold personal information are subject to no such standards. Any company that holds consumers' personal information necessarily or unnecessarily should be held to a national standard. Americans deserve a strong national data security standard that requires all businesses to protect and safeguard personal information. Companies that do not need to store personal information should either not store it or be subject to the standard. Companies should not be allowed to put consumers at undue risk. And communicating a data breach in a timely manner allows consumers and financial institutions the ability to try to reduce possible losses with early detection and awareness. The current system is not fair or sustainable. Consumers are protected from losses because financial institutions bear the responsibility for reimbursing them. Those that are negligent should bear the cost. Protecting data is expensive and it's labor-intensive, but a company that stores information needs to invest in these protections for consumers as a cost of doing business or not store the information at all. In summary, it is our hope that this committee makes data security one of its top priorities in 2018. We ask that any legislation proposed would include these three priorities. 1, a standard for all companies holding personal information. 2, a requirement to communicate breaches in a timely manner. And 3, a responsibility for negligent companies to bear the costs. We will work with you to protect consumer data and increase accountability. Companies may not want to invest in protecting data, but it is a matter of responsibility and duty that goes with holding that information. On behalf of Summit Credit Union and the National Association, I'd like to thank you for this opportunity to share my views, and I'd be happy to answer any questions. Thank you.
Thank you, Ms. Sponham. Gentleman from, Mr. Taylor is recognized for 5 minutes.
Mr. Chairman, Ranking Member Clay, and members of the subcommittee, my name is Nathan Taylor, and I'm a partner at the law firm of Morrison & Forster. My practice is focused on helping financial institutions and other companies protect the security of their sensitive information and respond to security incidents that unfortunately but inevitably occur. My colleagues and I have represented companies in responding to a number of the largest and highest profile data breaches in American history. I'm pleased to be here today to provide you with background on the state safeguards laws and the state security breach notification laws. At the outset, however, I want to stress that I share your concern about the critical need to protect American consumers and American businesses from the increasingly sophisticated cybersecurity threats that we face today. Cybersecurity impacts not only the security of our own sensitive personal information, but in our internet-connected world in which we live, it impacts our very way of life. In my view, we need a national standard to address what is truly a national issue. And I also believe that a national standard would ultimately be good for both the American consumer and American businesses. For more than a decade, I've tracked the state laws as they've developed in this area. When you review the current landscape of state laws, you find a complex matrix of inconsistent, sometimes duplicative, and often contradictory requirements. With respect to state safeguards laws specifically, today only 15 states have laws in effect that impose general requirements on all companies to protect the security of sensitive personal information. Most of these safeguards laws impose only a high-level obligation to take reasonable steps to protect sensitive information. Only a few include detailed security requirements, and those are often modeled on the safeguards rule issued by the Federal Trade Commission pursuant to the Gramm-Leach-Bliley Act. In contrast, however, today, 35 states do not have generally applicable laws that require all companies to protect sensitive personal information. If you are an American, where you live should not impact whether there's a legal obligation to protect sensitive information about you. In my view, this point is not controversial. We need a national standard for security to ensure that all Americans are protected, while also leveling the playing field for American businesses. With respect to breach notification, 48 states, as well as the District of Columbia, Guam, Puerto Rico, and the U.S. Virgin Islands have enacted breach notification laws. Although these laws ostensibly share the same purpose, they are far from uniform and vary significantly in terms of their requirements. For any given breach, the many differences among the laws impacts whether, at all, a consumer receives a breach notice, what that notice says, when it is sent, and even how it is sent. In addition, the inconsistencies among these laws complicate the process for companies in providing notice to consumers. Even for companies who respond to an incident diligently, investigating a breach, restoring the security of systems, and providing notice to consumers takes time. It is a complex process that is made more difficult by the need to comply with 52 different breach laws. A single nationwide standard for breach notification would address this issue. In closing, I note that Congress, including this committee, has considered the issue of data security for 15 years. In my view, the time for Congress to act is now. In considering legislation, I would recommend that this committee be guided by 4 principles. First, a federal bill should include strong, yet flexible and scalable data protection standards for all companies. Second, a federal bill should require notice to consumers of breaches that put them at risk of harm. Third, a federal bill should include a safe harbor for compliance with existing federal data security standards. And finally, a federal bill should preempt state laws to ensure that all Americans receive the same level of protection regardless of where they live. Thank you for the opportunity to speak with you today, and I'm happy to answer any questions that you might have.
Thank you, Mr. Taylor. Professor Rotenberg, recognized for 5 minutes.
Mr. Chairman, Ranking Member Clay, and members of the committee, thank you for the opportunity to speak with you today. My name is Mark Rotenberg. I'm president of the Electronic Privacy Information Center. We are a nonpartisan research organization established in 1994 to focus public attention on emerging privacy issues. I've also taught privacy law at Georgetown for more than 25 years and am the author of several books on privacy law. I've provided for the committee a detailed statement that I ask be entered into the hearing record. I'd be happy to briefly summarize my comments, if that's okay. Thank you. Let me say at the outset that data breaches today pose an enormous challenge, not only to American families, but also to our country. Previously, consumer privacy laws were enacted to safeguard consumers against the misuse of their personal data. But what we are increasingly aware of is that foreign adversaries are targeting the personal data stored by American firms here in the United States. And you see, as a consequence, when companies engage in lax security practices, they put their clients and their customers at risk not only of the misuse of the data, but also of identity theft and financial fraud from foreign actors. A related concern that I would like to bring to your attention is the growing divergence between U.S. privacy laws and privacy laws in Europe. As you may be aware, the European Union is moving in May of this year to establish a comprehensive approach to privacy protection known as the General Data Protection Regulation. That law is already having a big impact, and I would say a positive impact, on the practices of U.S. firms operating in Europe. But the increasingly critical question is whether the United States will update its privacy laws to address growing concerns about the protection of personal data held in the U.S., not only on U.S. consumers, but also on the consumers in countries where we do business. So for both of these reasons, I think there's an enormous urgency in this committee moving forward strong proposals for privacy protection. And I've outlined in my testimony several key principles that I hope you will consider, as well as brief comments on some of the bills that are pending in this committee and elsewhere in Congress. I want to comment on a few of the points that were made earlier and highlighting also statements that are in my prepared testimony. I think the key point is that you want to establish a federal standard, but it should be a federal baseline standard. And this is the traditional approach to privacy protection in the United States. If you go back to the Video Privacy Protection Act or the wiretap statute or other consumer privacy laws, the approach to privacy protection has been one that recognizes, as the other witnesses have said, the need to ensure a federal standard that provides baseline protection, but also allows the states to regulate upwards and to respond to emerging privacy threats as they emerge. Just looking at the field of data breach notification and the experience in the state of California, what you will see is that as the state confronted new forms of data breach, first it was financial fraud and then it was medical records, the state was updating its laws to address the new challenges and to provide new and necessary coverage to ensure that consumers would be aware of the new types of data breach. This is entirely consistent with our federalist form of government that leaves to the states the authority to establish stronger privacy protections when necessary. So I would certainly agree with the other witnesses on the need for a national standard, but I would urge that that be a baseline standard. Some of the other key points in my testimony include the need for prompt breach notification. It simply takes too long today to tell people that their personal data has been compromised. In the credit reporting industry, we think it's important to establish across-the-board data freezes so that consumers can make the determination affirmatively when to disclose their personal data to others, rather than to have to wait until the breach occurs and then to take additional steps to safeguard personal data that has already been compromised. I'd be pleased to address other points in my testimony, and thank you again for the opportunity to speak with you today.
Thank you, Mr. Professor. Mr. Rosenzweig, recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Clay, members of the committee. I thank you for the invitation to join you today. My name is Paul Rosenzweig. I'm a senior fellow at the R Street Institute. We characterize ourselves as a pragmatic think tank, which I guess means that we think the free markets work except when they don't. There is good evidence that the free markets do not fully work in the cybersecurity arena, and that the market does not adequately price in the costs of cybersecurity. Recent history is, of course, replete with examples of data breaches, like the Equifax breach and the harm they have caused. I myself have been the subject of at least 3 breaches in the last couple of years: Equifax, Home Depot, and the OPM breach. And as the Verizon data breach annual report reflects, in 2016, the last year for which we have some data, more than 40,000 incidents and 2,000 confirmed breaches have occurred. So make no mistake, cyber threats are real, and recent experience has shown that neither the private nor the public sector are fully equipped to cope with them. Given these threats, we should expect that the market would provide a solution. Why is that not enough? The answer, I think, lies in the conception of externalities, that is, the fact that activity between 2 economic actors may directly or unintentionally affect a third party. Cybersecurity has those types of negative externalities. The most important one is what we call a pricing problem. That is, that private sector actors often do not internalize the costs of security failures in a way that leads them to take adequate protective steps. When software fails to prevent an intrusion or a service provider fails to interdict a malware attack, the costs are borne entirely by the end users. In this way, security for the broader internet is a classic market externality. How then should government respond to this problem? First, and most importantly, we should guard against what public choice theory calls rent-seeking. That is, the idea that we should not foster the right result, but rather the result that concerted lobbying efforts favor. Second, we must be careful of inflexible, slow-to-change mandates. The government's hierarchical decision-making structure allows only slow progress in adapting to this phenomenon, and operates far too slowly to catch up with the pace of cyber change, if you will. We make decisions at the speed of conversation, but change happens at the speed of light. Of course, whenever we've chosen to address a pricing problem through litigation, there are also significant costs, most notably transaction costs. Operating a civil justice system is expensive, and participating in that system even more so. Those costs, which are unrelated to the merits of the failure or the litigation, have a strong tendency to distort the market in ways that are often unanticipated. So then what's the right approach? My counsel to you would be, first, do no harm. In the end, if a regulatory approach is chosen at all, it should be flexible and scalable to a standard-setting approach with a light administrative enforcement mechanism, rather than a hard mandatory approach with a heavy civil sanction. Most importantly, we must develop a system that creates more certainty than it does uncertainty. And that requires 2 things: guidance and reassurance. As to guidance, we need a model that relies on a flexible standard, but also one that is clearly articulated. By contrast, for example, today, much of the guidance from the FTC to consumer enterprises on acceptable cybersecurity practices comes in the form of consent decrees that, taken together, articulate a very indefinite standard of reasonable behavior. That's a poor way to set standards. Second, no enterprise will invest resources in achieving standards without some assurance that doing so will benefit the enterprise. In reality, a major portion of that benefit will lie in the fiscal security of knowing that the enterprise has taken adequate steps to avoid liability. So we need either an implicit or an explicit form of safe harbor that encourages people to adopt the standards we develop. So what should our standard-setting system look like? We have a good example in the NIST framework, a kind of collaborative, bottom-up approach that collects best practices and advocates for them as the best standard available. If we follow these precepts, if we focus on standard setting rather than rulemaking and guidelines rather than mandates, we'll go a long way towards advancing cybersecurity and ameliorating the failures in the marketplace. I should caution that no solution we can devise will be perfect. This is truly an insoluble problem that cannot be eliminated altogether. But there are, in fact, better or worse answers, and I commend the subcommittee for its attention to the problem, and I look forward to answering your questions.
Thank you, Mr. Rosenzweig. Appreciate your comments this morning, although they're very ominous. You just said we couldn't solve the problem, so at least we can talk about it, huh? Congress is really good at that. We can talk a lot, can't we? With that, I'll recognize myself for 5 minutes and begin the questioning. Again, thank all of you for your comments. You know, we, as many of you indicated, we have almost daily breaches now, and the American public is clamoring for some sort of solutions to some of these problems. And we're trying to put together a bill that hopefully will address some of the concerns and take into account some of the suggestions that you have given us this morning, and we certainly appreciate your input. Let me start out with Mr. Rosenzweig with regards to one of the issues I think that's key to this whole situation is the preemption of state law. All of you mentioned, I think, this very thing. You know, I think, to me, it looks like we have two choices. One, you preempt state law and be able to protect consumer data, or the other is you allow the hodgepodge of laws to continue and that the consumers beware. Where would you come down on this?
Well, I would, rather than characterizing them as a hodgepodge, I would say that federalism and competition is one of the ways that a market can function. The other way is to impose uniformity across the entire nation. That has the economic advantage of eliminating redundancies and conflicts and reducing costs. What I would say is the worst answer, or the worst of both possible worlds, is to partially preempt state law, to set a baseline standard that does away with federalism in the first instance, but doesn't eliminate the uncertainty of multiplicious laws in the second instance. You don't gain any of the benefit, and you lose, and you cost a lot.
Would you believe that if we had an across-the-board exemption that allowed for a federal standard, that would provide a better safeguard for data for people, though?
I think, as an economic matter, if you're going to
I'm
go
talking
down the
about
road,
economics. I'm talking about the ability of people to protect their data.
there would be more consistency and therefore more likelihood of full compliance. The inconsistency of the rules is part of what generates some of the uncertainty. So yes, sir.
Okay, thank you. You make a good attorney. Let me go with the question with regards to notification. I know this everybody has a different idea of this. If you talk to the companies, they want, you know, and we've seen the examples of this anywhere from 2 weeks to a year before people were notified. You know, the American public deserve better than that. And because of those, in my mind, lousy way of trying to work and manage their breach, they've lost the trust of the American people. So I don't know how we can get it back unless you go to a zero, immediate notification. This is what I think we need to go to, and I think the American public is going to clamor for this, and I think my thought process is that while the breach is going on, you know what's going on, and you're ascertaining exactly how much information, what information was lost, whose information was compromised, you can already know, okay, we've got a breach. Now we've got to start setting up some sort of notification process, and I think you can do 2 tracks on this so that whenever you finally do realize that you have a compromised situation or you have to be notifying people, you can do that on an immediate basis. Anybody like to comment on that? See where you are on that.
Mr. Chairman,
Yes,
I agree with you. I think, in fact, our recent experience with Equifax demonstrates the need for prompt breach notification. The company was aware in March of 2017 that they had a problem with a key security protocol that they failed to update. Yet it wasn't until August, 4 months later, that they actually took steps to begin to notify the public of the potential that their data had been breached. And of course, as long as that software was not updated, the breach was ongoing. So the breach is necessary not only to provide information to consumers so that they can act, but also to ensure that the company is being diligent when it uncovers a problem.
Very good. Anybody else like to comment on that? Ms. Bonham?
We had a situation in Madison where there was a local processor that processed credit cards for various restaurants, and they had been breached and did not notify anyone. It took them weeks and into over a month to start to work on the patches that they needed to do in order to shut that down. So meanwhile, the hacker, every single time someone used their credit card at one of those restaurants, they were just getting new credit card information. We had customers who had to get their credit card reissued 4 times during that period.
I'd like to make one quick comment. I know that yesterday in the National Journal, there was an article with regards to Europe beginning to come out. I think, Professor, you made this comment with regards to new data rules coming out. In their data rules, they're looking at a 72-hour window within which to disclose this, although it doesn't say in here whether you actually ascertain exactly the kind of information that's been breached, and you know that there's actually some people's information been compromised. I think that's a key component of this. But just a quick, would everybody agree that immediate notification has got to be there, or some other time frame? Mr. Cooper?
Mr. Chairman, I think it's really important that there be prompt notification, and I think that the response from companies needs to be strong and immediate, but we also need to look at what's going to be best for consumers. And one of the concerns about having an artificial deadline about when notification has to happen is that the initial information is not always the accurate information. It's more important that the information be accurate than that it be fast.
Very good.
And I think that with the FTC and state attorney generals being able to make that determination.
Very good. My time is up. I've set a good example here. You'll all be able to come to, hopefully my guys have been listening over here. We're going to get some good questions on this because this is a key component, I think, to be able to go forward here. With that, Mr. Clay from Missouri is recognized the ranking member is recognized for 5 minutes.
Thank you, Mr. Chairman. And Professor Rottenberg, you have written previously that without comprehensive legislation, the data breach problem will only get worse. As part of such legislation, what type of personal information should be explicitly covered?
Mr. Clay, this is a critical question, not only because personal data such as home address and social security number and financial records and educational records are readily understood as personal data, but also increasingly in an era of big data, we have a lot of information that is de-identified but can be reconstructed as personal data. So when we talk about personal data in the 21st century, we need to understand that it's information that appears as personal data and is familiar or could be made personally identifiable. So as a starting point for privacy legislation, we think it's important that there be a broad scope and that this particular problem be well understood.
And should a harm threshold be used to trigger notification of a breach, or should all breaches be disclosed?
Well, this is a critical question. The problem with the harm threshold is that it's oftentimes left to the company to make a determination about whether they think the consumer has been harmed. And in our view, the better approach says to the company, if a breach has occurred, notify the consumer and then let the consumer determine the scope of the harm. Oftentimes, companies don't have the full picture of what the consequence will be if customer data is breached, and that's why we think that the harm standard is too high. It results in too little notification.
Thank you for that. In your testimony, you mentioned that credit rating agencies should have an automatic credit freeze. Could you expound on that and tell me how would a consumer unfreeze that credit?
Right. Well, I think this is just common sense. As we also say, the credit reporting industry is vital to the American economy, and consumers need the ability to obtain credit to get a home loan or purchase a car. We all understand that. But when the consumer is making one of those big life decisions, the person should be able to say, okay, now I want this company to have access to my credit report. So it becomes an affirmative decision. The problem with the current system is that companies routinely get access to personal data, whether or not the customer has any intent of doing business with the company. And this also contributes to identity theft. So if we change the default, give consumers the ability to disclose the customer report, the credit report, prior to the purchase, we think that would be good for the customer, it would be good for the merchant, and would reduce the levels of identity theft.
Would that have had an impact on the Equifax?
Absolutely. I mean, the problem with Equifax is the data became widely available, and consumers were asked after the fact to race around and put credit freezes in place, and at that point, it's too late.
Yeah. Hey, in recent testimony before the Senate, you underscored the implications that the massive Equifax breach has for U.S. trade relations, citing the fact that more than 15 million UK customers were impacted, and the fact that the data exposed by the breach is, as you put it, a gold mine for identity thieves. Can you expand on that concern?
Well, this is the point that I raised in my opening statement. Traditionally, when we talked about privacy law in Congress, the focus was the impact on U.S. consumers. But of course, now we live in a global internet-connected environment. Many U.S. companies are doing business overseas, and those governments are looking at U.S. privacy law and trying to assess if we have adequate privacy protection for the records of their citizens. So when the Equifax breach occurred, it didn't just impact American consumers. It impacted people in the UK and Canada and elsewhere around the world. I think it's very much in the long-term interest of the U.S. economy to strengthen our privacy laws, because other countries are becoming increasingly concerned about the weak privacy standards we have.
And you did mention that the EU was moving forward.
Yes, that's correct.
With an initiative, and we should probably look at that also and take some of the good points of it, I guess.
Thank you.
Thank you. I yield that.
Gentleman yields back. With that, we go to the gentleman from Pennsylvania, the Vice Chairman of this committee, Mr. Rothfuss, recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Bonham, in your testimony, you discussed how merchants and other companies that are not banks or credit unions are a source of vulnerability and cost. You wrote the following: financial institutions like Summit Credit Union foot the bill for the fallout and subsequent fraud that comes from the breach of personal information from merchants and other companies' failure to adequately protect and secure customer information. In your experience, are merchants and other non-financial companies a major avenue for data breaches? Your mic.
Yes, I believe that they are a major avenue for breaches. I believe that most breaches do come from those sources.
And can you quantify again how much these breaches cost your credit union annually?
So in 2017, we spent over $1 million on breaches, and that has increased year over year. So in 2013, it was around $350,000. It increased 20% in 2014, and today it's over $1 million.
Mr. Taylor, while I agree that cybersecurity and breach prevention and notification should be national concerns, I also acknowledge that small businesses may pose less risk and have fewer resources available to address potential risks. What is the best way to tailor data security and breach notification requirements to the characteristics of businesses that vary in size and capacity?
It's a great question, and I think the key is that you have a flexible and scalable standard, right? And that's something that a number of us on the panel have highlighted today. You need a standard that takes into account the size, complexity, and scope of the business's operations, so that a standard that can apply to the smallest company in America to the largest, right? I think it's critical that everyone has at least some obligation. But then, the amount of resources that you have and the size of your organization should dictate the extent of the expectations.
Do you know what NIST's role is in setting cybersecurity standards?
The NIST issued the cybersecurity framework pursuant to a executive order.
Are entities required to use the NIST framework?
No.
What federal agencies should enforce the law and determine what compliance with the law in this area would look like? Any opinion there?
Yeah, absolutely. I think you have to recognize a couple points here. First, we do have existing standards under the Gramm-Leach-Bliley Act and under HIPAA. And I think for those areas, you should continue to follow the prudential regulation model. For example, financial regulators enforce over the financial institutions. And then I think that when you're looking for who else should enforce, I think you have to start with the Federal Trade Commission, right, who has historically played a very active and strong role in this space.
Mr. Cooper, if I can ask you, we all recognize that Congress does not want to create a situation whereby breached entities are forced to inundate consumers with insignificant notifications to the point that the breached entity is notifying Wolf. With that in mind, where should the responsibility and authority reside in determining a direct risk threshold of identity theft that would trigger a notification?
I think, again, we need to look at it from the perspective of what's going to be helpful for the consumer in responding to a breach that might have an effect on them. I think they are most likely going to be responsive to the entity that they know has their data. So in Ms. Bonham's example, for instance, the restaurant that a customer went to where their credit card was used, making sure that that entity is communicating with the customer, I think, is crucial with some actionable information so that it's not just a notice that there has been a breach, but here are things that you can do.
Mr. Taylor, if I go back to you, in your testimony you described the current patchwork of state notification laws as a, quote, complex matrix of inconsistent, sometimes duplicative, and often contradictory requirements. Clearly, there is a case to be made that a national standard would be more appropriate and that it would significantly reduce the compliance burden for firms. If we were to establish a national breach notification standard, what information would need to be included? What do consumers need to know if their information has been improperly accessed or stolen?
I think there's a few key points that you should focus on. First, a description of the incident, what happened, what information was involved, what the company's doing about it, and steps that the consumer could take to protect herself from harm.
Yield back. Thank you.
Gentleman's time has expired. Then we go to the ranking member of the full committee, Ms. Waters, California, recognized for 5 minutes. Welcome.
Thank you, Mr. Lukemeyer. I have an opening statement that I'll submit for the record, and I appreciate your holding this hearing. Mr. Rothenberg, Chairman Henselin has said that in light of the Equifax breach, it should be obvious to all that our committee will revisit the Data Security Act legislation that our committee took up nearly 2 years ago. The law included sweeping language that would have preempted state law, and which the Massachusetts Attorney General at a Minority Day hearing that Democrats called indicated would drastically undercut Massachusetts data security regulations. The New York Attorney General's office agreed with this perspective in their testimony before our committee. So in your view, if the choice is between the status quo or federal legislation that preempts states' ability to take action to protect consumers and bolster data security requirements, which option would you prefer?
Thank you, Congresswoman, for the question. I'm somewhat familiar with the Data Security Act, the 2015 bill, and also aware of the objection of many state officials and consumer groups. I think it would be better not to preempt state laws that currently provide strong protections to consumers. I think there's a very real risk, in fact, that if you pass a national standard that's weaker than what many of the states currently provide, you will see an increase in the levels of identity theft and financial fraud in the United States. Because it's actually those state officials and the state attorney generals on the front lines of this problem who are dealing with state residents and businesses trying to come up with the best legislative solutions. So the practical consequence of capping that effort would be to remove the most well-informed, the most effective, and the most responsive policymakers from this field. I think would be a terrible mistake. Now, I do think Congress has a role to play and has always played an important role establishing a baseline standard when it becomes aware of an emerging privacy issue. And most certainly, the protection of personal data is an emerging issue. But I have no difficulty saying quite simply a measure that would preempt state law would leave many more American consumers at risk of identity theft and financial fraud.
Thank you. And in some discussions that I've had with some members here, they have said that this area that we're dealing with, cybersecurity issues, that you need flexibility and you need to be able to continue to strengthen your efforts to ensure that you have the kind of protections that are necessary, and that means that the states may be able to move faster, may be able to initiate changes, upgrade, do all kinds of things that perhaps the Congress of the United States could not easily and readily do. Is that a concern?
Well, I think that's the actual experience in this field. I think there are some fields where there's no question that Congress does need to establish a comprehensive national standard. But I think there are other fields, and privacy is most certainly one, where the nature of the subject matter and the expertise that exists at the states underscores the need for our federalist approach to coming up with innovative solutions. It was actually Justice Brandeis, known for his famous opinion on the right to privacy, who also described the states as the laboratories of democracy. And we see that in the protection of privacy. This is where the innovative legislation comes from.
Well, my concern is that when you start to talk about national standards and you're dealing with all of these members of Congress who come from different states, and you have to basically come up with an agreement, a consensus, dealing with all of the concerns, that the national standard is usually a race to the bottom almost, and that it does not recognize that some states, such as been identified by New York and Massachusetts, have good standards, higher standards, and a national standard would certainly not match that which some states already have and could have. So I thank you for being here today. I appreciate your testimony, and I think that we should take into consideration what you have said, because preemption of state laws is a serious effort that should be taken seriously and not done in the interest of just trying to have something. I yield back the balance of my time.
Gentlelady's time has expired. With that, we go to the gentleman from North Carolina, Mr. Pittenger. He's recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for leading this very important hearing. I would like to again thank all of our witnesses for being with us today. Your input is so critical for each of us on this committee. Clearly, data and cybersecurity need to be at the forefront of the agenda for the United States Congress. Over the last several years, we've had big and small companies that have been affected by related security breaches. And obviously the Equifax is at the forefront of an issue that we've all sought to consider and evaluate where we go forward. I would like to ask at this point, Ms. Bonham, what's the nature of the FTC's oversight of the credit bureau's data security operations? Would you expand on that some more?
What's the oversight of the FTC with regard to this issue?
To the credit bureau's data security operations.
So we fall under the GLBA standards, and we believe that we're required to follow those, and we believe that they should as well.
Sure. How does the FTC's oversight of the credit bureaus measure against the data security regulatory frameworks in other sectors of the economy, such as retail, hospitality, education, et cetera? What is your view of that?
I don't know where the standard should fall under, but I do believe that those standards should be fluid. For example, with the standards that we followed 5 years ago, if we were continuing to follow those same standards today, we would have been hacked by now. So those standards need to continue to evolve over time, and they need the flexibility to be able to do that as people get more sophisticated in being able to penetrate different systems. So where that falls under and what that looks like, I don't know, but I think it is really an important piece to make sure that we have in place.
Yes, ma'am, thank you. Mr. Taylor, do you think it's important to empower law enforcement to share information with the private sector in respect to ongoing cyber threats and attacks? If you could allude on that some more.
Yeah, absolutely critical. If law enforcement is aware of threats and if companies had that information, they could take steps to protect their systems. Absolutely critical. And I think from an industry perspective, even following the Cyber Information Sharing Act, I think there's been a cry from the industry generally for more information, particularly from the federal government, on threats and vulnerabilities that exist today.
Yes, sir. So you would say that there should be greater information sharing among themselves in the industry and the private sector on ongoing cyber attacks?
Yes. And I think it's developed historically in a very sectoral approach, right? The financial services and retail and technology, they all have their information sharing and analysis centers and try and share threats amongst themselves. And it's something that's developing and growing, I think, over time.
Is there anything we should be doing on the federal level to encourage information sharing?
Can you repeat?
Is there anything we should be doing on the federal level to encourage information sharing?
Well, this Congress did pass the Cyber Information Sharing Act, which ostensibly was for that very purpose, and I think that we need a reminder, to federal law enforcement to encourage them to share with the private sector information about threats.
Yes, sir. Thank you. Mr. Rosenzweig, who has the enforcement authority for the various data security regulatory regimes? Is it the FTC, the State Attorney General, or banking regulators?
It's a patchwork, sir, and it very much is sector dependent. Right now, the FTC has significant authority over consumer-facing institutions. States attorneys general have authority within their respective jurisdictions. Under Graham-Leach-Bliley, there's regulatory authority under the from the banking groups, HIPAA as well. Yeah. So one of the things that we see, as Mr. Taylor said, is kind of a sectorally developed set of privacy and security rules that has created some uncertainty as to where you fit within the matrix, pretty much.
Yes, sir. Thank you. Just very briefly, then I would ask you, how can we ensure that Americans' data privacy and data security interests are best served by the national data security and breach notification standards?
Well, I would start by saying that I don't think that data breach notification is cybersecurity. It's an ancillary to it because it has the collateral effect of embarrassing people, but it only comes after you've failed. The right way, the primary way, I think, would be to foster things like the standard setting at the NIST that we've been talking about already today, and propagate that throughout industry so that we get a kind of best practices level playing field that is a good standard setting model.
Thank you. My time's expired. Thank you very much.
Gentleman's time has expired. With that, we go to the gentlelady from New York. Ms. Maloney is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank you and the ranking member for holding this important hearing, and all of the panelists for your truly riveting testimony that underscored the urgency of acting on the federal level to protect the information of consumers. I'd like to first ask Professor Rottenberg about the importance of breach notification. I think we all agree that when a company is breached and personal information is stolen, consumers should be notified as quickly as possible. But before they can be notified about a breach, someone has to discover it. Usually it's the company, but sometimes it is discovered by a third party that the company's hired as a vendor who discovers the breach first. Now, a number of vendors, independent tech companies that have huge platforms are opposed to this. And personally, I think a third party should notify as quickly as possible. But my first question is, if a third party that a company has hired discovers a data breach at the company, do you think the third party should have an obligation to notify the company of the breach?
Thank you, Congresswoman, for the question, and the simple answer is yes. We need more breach notification. We need companies to be made aware of when they have problems securing the data they collect. And I thought a lot about how best to describe the problem and this question in particular. Imagine, for example, that you made your home available to a friend, and the person goes into your house, and the first couple days they're there, a pipe bursts. You've got water pouring all into your house. Now let me ask you the question. Do you think they should contact you right away when the pipe bursts and the water's pouring over your house? Or should they wait a few days or a couple of weeks or maybe to when you get back home and you're looking around and you're saying, gee, what happened here? Oh, well, the pipe burst. Maybe someone should deal with it. Data breach is actually very much like a pipe bursting. You've lost control over the information that you have a responsibility to protect. And if you don't act quickly, and if you don't notify somebody who has the ability to fix the problem, it simply gets worse. And as I tried to explain at the outset, the people who are targeting personal data in the United States today are much more sophisticated than the people, 10 years ago or even 5 years ago. These are foreign adversaries. They're trying to uncover national vulnerabilities that they can exploit. I think we need breach notification, that's almost immediate, but practicable. 72 hours, which the Europeans chose, I think is probably a good target.
I thank you for that excellent reply. And in fact, this article that actually the chairman loaned to me talks about the European Union. In May, they're enforcing their 72-hour reporting time, which in a sense will enforce it in America too, with those companies such as Boeing and GM and Chevron and Microsoft, to mention a few that are international companies. They're going to obviously have to start responding to what the European standard is. So Europe's data rules are headed to the United States. It used to be, as the financial capital of the world, the United States would set the standard. Now we're rushing to catch up with what the rest of the world is doing in a very important area. I must say that after Equifax, I'd say probably half of the people on this panel were breached, and myself included, and it took them 40 days to disclose that 145 million Americans had lost their security. And I agree with you that the 30 to 60 days that companies in America are demanding is just too long. I think we should move to the European standard, and actually it's being enforced on our people now through the law that is going to start being enforced in May from the European Union. I ask unanimous consent to place in the record this important article that shows the fierce urgency of acting now to move forward on it. I will say, I talked to the ranking member, and he's going to join me with some questions that I'd like to get everybody in writing, because we don't have much time. We have 5 minutes. And I spoke to the chairman. He said if he approves, will join us, which would be great, on getting everybody on record on some of these things. I can't even be left alone in a hearing, it's going off. Anyway, so I'd like to ask Nathan Tailor, you mentioned in your testimony that some states sometimes have a data breach notification laws that are inconsistent and directly conflict with each other. I'll give you an example. You noted that some states require companies to tell consumers as much information as possible, while others say you can't. So we need a uniform. My time is expired. I look forward to sending each of you a thank you note for your excellent testimony and some other additional informations that we can see if everybody's on board on certain changes that we as a nation should move forward on. Thank you so very much. I yield back.
Gentlelady's time has expired. With that, we go to the gentleman from Colorado, Mr. Tipton, recognized for 5 minutes.
Thank you, Mr. Chairman. Thank the panel for taking the time to be able to be here. Mr. Cooper, I'd like to follow up a little bit on my colleague, Mr. Rothfuss's question in regards to some consumer confidence. Obviously, if we don't have confidence in the data being able to get out into other hands, we undermine the entire process in the eyes of the consumer. You'd cited one instance to be able to help restore some of that consumer confidence by just notifying people that a breach had occurred. Are there other measures that we should take as well?
Yeah, so I think one of the best aspects of both the proposal for legislation in this area and even this hearing is raising the visibility of the importance that anybody who is a steward of data is responsible for making sure that they take reasonable steps in order to keep that data secure. It's important for what Ms. Bonham's credit union does. It's important for what our members do, because 90% or so of data breaches can be prevented just by having good cyber hygiene. And if more companies are adopting a NIST-style framework in order to make sure that they are protecting their data, that they are making sure that passwords are protected, that credentials are protected, will resolve a lot of the data security incidents that we see.
Thank you. And maybe as a little follow-up on that, and Ms. Bonham, Mr. Tailor, you might want to weigh in on this as well when we're talking about who is responsible. Can you maybe explain the way in which institutions, which third parties, retailers, who is responsible for the costs of a breach?
Yes, so today, the financial institution is responsible for any entity that is breached that impacts our members negatively. So if it impacts their credit card or that depletes their debit card checking account, we reimburse our members for those fraudulent charges. In the case of loan fraud, we also do all of the reimbursing of any fraud that takes place from a fraudulent loan. We've increased our costs from trying to identify more fraudulent loans, as that has been on a large increase over the last year. And so things that we might do is make sure that the Social Security number issuance matches date of birth. We will check IP addresses on the loan apps to make sure that the IP address is from the same state. We look up people on social media to make sure that the details match. We check driver's license numbers on the DMV website. So we have gone to great lengths now in 2017 to protect that information, to protect our members from fraudulent loans being made. And I believe that those entities that are negligent in protecting consumers' data ought to be held responsible for the costs of those data breaches.
Ms. Taylor?
Yeah. Statutes today don't define liability, right? This is a heavily litigated issue, whether it be among companies for a company's fraud losses or a consumer's losses, right? That's something that is pursued in courts today to define the liability.
Okay. So ultimately, right now, liability is landing literally with the banks, with the retailers, and we need to have that applied a little more on a broad base. Would that be fair to say?
I think liability is an extremely controversial issue. My personal view from my practice is I would tend to lean towards leaving it to the private sector to work it out amongst themselves and define and allocate risk.
Great. Go ahead.
I believe that companies who do not take the added steps in protecting consumer data ought to pay for it. I don't know why we would want the banking industry to be at the risk of all of these different entities that are not protecting consumers' data, and oftentimes ending up in identity theft, which is a much greater problem for consumers.
Do you have any ideas on really how much we should be spending, a broad-based question, obviously, in terms of cybersecurity? How much of the resources should be allocated for cybersecurity in businesses?
If I may, I'd say that it really depends on the type of business that we're talking about. The restaurant local restaurant probably has a different amount of resources that it should be putting into its cybersecurity than a web hosting company or a financial institution or a large multinational company that collects and maintains a lot more data. So I think one of the keys in having a data security set of rules is that they be flexible and scalable depending on the type of company that we're talking about.
Great. Thank you. Yield back, Mr. Chairman.
Gentleman yields back. With that, we go to the distinguished gentleman from Georgia. Mr. Scott is recognized for 5 minutes.
Thank you, Mr. Chairman. Panel, very good discussion, really very enlightening. But I tell you, I'm very worried. I'm worried about the future of our nation. It seems that we're in a sort of cyber data breach world war. And I think we need to look at it that way. And the United States of America is the #1 target. But I am worried about our inability to adequately respond to this. First of all, you take the fact of Equifax, 145 million people with all of their vital information out in the open, breached upon, and what happens? We first put the Consumer Protection Agency out front doing an intensive investigation, and then all of a sudden, we draw that investigation back. There's nothing. I don't know of anybody right now, any federal agency, that is investigating that breach. especially from a standpoint of even all the information that we had. They waited 2 months before they even notified anybody. They didn't wait that way when 3 of their top executives sold their stock once they found out what the breach was and made millions of dollars. No investigation. I want to ask you, do you think 6 weeks to notify the public of a breach was fair to the American people? Anybody here think that was fair? I don't think so. Everybody's shaking their head that it didn't. Do you think that the CFPB should have backed away from this investigation? Where do you think that the feeling of the American people are resting now? Well, let me ask you this. Under Graham Lynch Bailey, do you think that part of the problem may be that there is no delay in notification requirements that's even explicit within Graham Lynch Bailey? Do you think that may be a part of the problem, Mr. Rosenweg? Or you, Mr. Cooper? Do we have anything adequate to respond to this?
Well, thank you for the question, Mr. Scott. As most of the members of the panel have suggested, the absence of any time frame requirement for notification, it does lead to uncertainty within the marketplace. I think perhaps unlike some of the other panelists, and perhaps unlike Mr. Rotenberg in particular, I don't think a fixed time frame is necessarily the best answer. I think that sometimes delay is both necessary to ascertain the facts, and sometimes delay is necessary as part of the investigative process underneath the law enforcement interests. That is not to say that the Equifax delay is an appropriate delay. I don't want to be heard to say that, but for me at least, I would prefer a non-determinative, more flexible standard of notification requirement.
Well, let me ask you, Mr. Cooper, you mentioned, you said in your testimony that data security is a shared responsibility. What did you mean by that?
When a company is collecting and using data, and it might be using another company to help store it or process it, provide customer relations management tools, HR tools, there's a need to protect the infrastructure. There's also a need to protect the passwords and credentials that are being used to access that information. And it's different companies that have different responsibilities as part of that security system.
Now, let me ask you, Mitty, it seems like right now, from my observation, we have a hodgepodge of different regulations, different agencies. Wouldn't it be good for us to start trying to figure out how we can zero in and harmonize and get at this in a targeted way to protect the American people's information?
I think having the Federal Trade Commission have the lead responsibility to make sure that reasonable security measures are being taken and that notice is given to consumers when there is a breach in a reasonable amount of time will help make sure that there is timely notification, because there's the Federal Trade Commission there to say if you have not provided notice when you should have in a reasonable amount of time, the FTC has enforcement authority.
Thank you, Mr. Chairman.
Gentleman's time has expired. With that, we go to the gentleman from Texas, Mr. Williams, recognized for 5 minutes.
Thank you, Mr. Chairman, and also Ranking Member Clay. I want to thank you for holding today's hearing. As we've seen in the past year, cybersecurity breaches and the loss of personal identifiable information unfortunately continues to affect hundreds of millions of Americans, the Equifax breach being the largest example. Now, bad actors are not stopping, in fact, quite the opposite. Organizations around the country continue to be under constant threat from cyber thieves seeking to steal personal data. Our constituents expect us to, where appropriate, consider solutions which successfully defend their information and let them know in the event it's been compromised. Thank you to the witnesses. It's been good testimony today before us this morning. As this committee continues to work to find the answer in the space of consumer information safety and breach notification, and your expert testimony is welcomed. Ms. Spem, thank you for being here today to provide the perspective of credit unions in the data security debate. I'm a small business owner back in Texas, have been for 46 years, and a steadfast defender of Main Street. I'm glad to hear from you, and as you point out in your testimony, data breaches are becoming all too common. We've talked about that, and the cost institutions like yours have to bear to fix problems that weren't any fault of your own begin to add up. So we've talked a little bit about this, but expand on it. What kind of standards should merchants be held to? And will those standards effectively reduce the cost your institution must pay to assist members who are affected by merchant data breaches?
So I believe that merchants and other businesses that hold consumer information should have the proper controls in place as well. So it's the making sure that your patches are done in a timely manner, that you have the proper people in place to monitor those controls and to make sure that you're doing what you need to do to protect that data. So I think that that's, at what level of standards, I think that that's something that others will need to decide. But given the type of information that someone holds about consumers, I think does, as Mr. Cooper mentioned, does indicate to what level they need to be protecting that data.
Okay, thank you. Mr. Tailor, in your testimony, you recognize the harm that data breaches cause the American consumer. There exist today various state laws regarding the protection of consumer personal information and breach notification in the event that information is compromised. You are in support of a nationwide breach notification standard. So I ask this, why is a nationwide federal breach notification standard the correct policy rather than letting the states govern themselves?
I think it ultimately comes down, and the chairman in his opening statement said we can't forget about the consumer, and that's a point that I agree with. I mean, this is fundamentally about equal treatment for all Americans, right? Regardless, a lot of my family lives in Idaho Falls, Idaho. I live in Virginia. Our Social Security numbers are equally sensitive regardless of where we live, and the expectation should be the same for companies, regardless of where the company operates, to protect all of our socials.
I've got another question for you. In your testimony, you discussed the steps a company takes in determining the scope of breach. You say that while it may be simple to confirm the facts of what happened, in actuality, it takes detailed review before a company can figure out what happened and how to address the breach. One potential consideration that needs to be made when codifying a breach notification standard is the fact that, as you point out, when the breach becomes public, a company becomes a target for other attackers. So how long should a company be given to secure their systems before being required to make a public notification? And is there a risk that notification could happen too quickly and invite new attacks?
There's absolutely a risk. And speaking from my experience alone, I think there's a fundamental point that I'd like to highlight, which is all breaches are not created equal, right? They're really fact specific. And so going down the road of, picking times, whether it be days or hours, is really challenging because the breaches aren't alike. And it does take time, of course, depending on the facts, to both investigate, restore the security of systems, and that should be critical. Our expectation should be that a company should expeditiously investigate and take steps to protect their defenses. That's mission critical in my mind.
Okay, thank you very much. I yield my time back, Mr. Chairman.
The chair now recognizes the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Thank the witnesses for appearing as well. And am concerned about the liability aspect of this that my colleague across the aisle raised earlier. We seem to believe that there should not be a standard with reference to a timeline for reporting a breach, but we don't seem to think that there should be some sort of liability if that timeline is too long. If you wait until people are suffering such that they could not take some sort of action to help correct. Now, I think that businesses ought to be able to work out their problems, but what do you do when they don't? What do you do when they have millions of people at risk and their shareholders, some of whom happen to be in some pretty significant positions, my friend Mr. Scott mentioned it, they go out and sell their stock before they announce the breach. Now, if you think that it is appropriate for Equifax to have shareholders in significant positions, let's call them executives, to allow them to sell their stocks, probably can't stop them, but for them to sell their stocks before the breach is announced, if you think that's appropriate, raise your hand, please. Let the record reflect that no one has indicated that this is appropriate. So when this occurs, should there be some sort of liability? Do you think that people ought to be allowed to do this with impunity? Do you think that the poor guy who may not be able to afford a lawyer is going to be able to stop this? Do you think that class actions are going to be the solution when we've got a class of people right here in Congress who are fighting class actions, don't want lawyers to be able to bring class actions against these actors? So what is the solution? To debate it and do nothing? Why wouldn't there be some liability imposed if you knew or should have known that your security measures were inadequate and somebody is suffering as a result? So let's start with Mr. Rosenwick.
Mr. Green, thank you for the question. I would like to kind of divide the answer. If I don't know the facts of the Equifax case, they're still under investigation.
Well,
but
let's
assuming
not,
the facts as you propose them,
let's do this. Let's take them off the table,
right,
and we'll have our own fictitious entity.
I would say that insider trading is already a crime. And if you trade on insider information, that's an investigation that is appropriate for the SEC and securities enforcement authorities. I think that that's different from a generalized breach notification law. And there, I think that I agree with Mr. Taylor that the standard is or ought to be a flexible one that reflects expeditiousness at the most earliest reasonably practical time. The law is filled with flexible standards like that, the tort liability standard for the reasonable man sort of thing. I do tend to think that a firm
Excuse me, let me intercede for just a moment. What should be done when the flexibility that you speak of is abused?
Either an administrative enforcement action or possibly litigation. Those are the two possibilities.
Who pays for the litigation?
Presumably the people who are litigating.
Would that be the consumer?
We don't have a loser pays law here in the United States, so yes.
It would be the consumer. Why wouldn't Congress intercede and establish some standard that deals with this notion of flexibility? Let's assume that you're right, different circumstances require different time frames, but what happens when that is abused?
Well, that would be a matter for administrative enforcement, presumably through the FTC, or in the case of Equifax, through the banking regulatory authorities.
And I assume that, Mr. Taylor, you'd like to weigh in on this as well?
Yeah, I think throughout this hearing, liabilities come up in a couple of contexts, and I think what we've been talking about two completely separate issues. And I think the point that you're raising, Congressman, is a good one. If we're going to have a strong standard, we should hold companies accountable to that standard. And in your bill, you can provide penalties that you believe are appropriate for failure to comply with the standard. There's a separate liability issue that we've talked about in other contexts today, which is the liability that between companies who, when one company has a breach, there can be impacts, for example, to a credit union for reissuing cards, right? Those are two separate things, but on the former, I completely agree with you that we should hold companies accountable. If we're going to have a federal standard, we should expect that they comply, and if they don't, there should be penalties.
Time of the gentleman is expired.
Thank you, Mr. Chairman.
The chair now recognizes the gentlelady from Utah, Mrs. Love, for 5 minutes.
Thank you so much. A few months ago, one of our cybersecurity experts here at the Congressional Research Center, Chris Jakarian, testified before the Senate Banking Committee about data security. He outlined the process by which organizations typically respond to a breach, and I'd like to unpack that a little bit and get your thoughts on various aspects. Mr. Jakarian said that there will be a delay between the discovery of an attack and public notification of that attack because the analysis of what's transpired would need to be conducted. This analysis will inform the entity of how they were breached and what data systems were compromised, is what he said. Now, I understand that clearly an organization needs to know what happened before they can accurately notify people who were affected by the breach. But can we say that there should be, this is obviously a theme that I think both sides of the aisle are incredibly concerned about. We hear it over and over, and it's asked in so many different ways. I can't even imagine, your heads must be spinning. But can we say that there should be general parameters on the timing of notification? Mr. Cooper, I knew you wanted to say something earlier. You pushed your button, so I'm going to let you go ahead and answer that question.
Thank you. Yes, so I think that the complexity of the breach is going to affect when notification can happen in an accurate way, and I think accuracy is really important. I think that it's important that the Federal Trade Commission and perhaps state attorney generals are able to enforce a reasonableness standard in terms of the time when notification is provided so that we can figure out the parameters of what is reasonable and make sure that companies are held to that, so that a standard of reasonableness with no enforcement isn't a real standard. A standard that allows enforcement and penalties when it's not met will help make sure that there's not delays that are unnecessary.
Okay, so there's some serious questions, for example, about the lack of notification regarding Equifax breach. I would like to get your thoughts, Mr. Taylor, on that, because I think one of the analogies that was expressed about pipe breaking into your home, I mean, to me, the difference is when information is released and what type of information is released. And I would tend to think that there would be some sort of information saying, you know what, there's a pipe that broke. We don't know how. We will give you further information later about that, but there's a problem, and we need to notify you of that problem. So I guess I would like to just get your thoughts about regarding the notification, for example, and the lag of notification, because that's the serious concern here.
I appreciate your concern, and while I can't speak to Equifax specifically, I think what the fundamental issue here is, when does the clock start ticking, right? And I walked through this in detail in my written testimony. You know, when does a company, quote, discover a breach, right? Is that the first awareness of a fact that later, with the benefit of hindsight, is concluded to have been related to the breach, or is it the moment that the company says something's wrong? We have an issue here. And my point is, there should be an expectation that a company expeditiously investigates to figure out what happened and restore the security of their systems. And that's, in my mind, when the clock should start ticking, once those steps have been done.
Okay, so when a breach occurs, should there be a specific time frame for notification established in law? Is there something that we should do to make sure that there is some sort of a time frame?
If by time frame you mean something like days or hours, I would say no. I think you should go with a standard that is, you know, as expeditiously as possible, or as, you know, as reasonably possible. I think you need a flexible standard, because all breaches are not created equal. Mm-hmm. They're very different.
Is it realistic to require that any company notify customers within a set number of days or whatever circumstance? I mean, is there some sort of reasonable standard that should be out there?
I think, again, it really depends. It depends on the facts, right? It's a company needs to know whose data was lost in order to be able to notify the right consumer, right? You don't want to notify the wrong consumer and unduly alarm them.
So I have just a few seconds, but I just wanted to say that we are here on behalf, I believe, I keep saying this, the branch of government that's closest to people is the House of Representatives. And we will not be doing our job if we are not looking out for the people whose intellectual property has been breached and released. So our job is to protect the people. It will always be that. And so I think it is our responsibility to make sure that there is something that is there that we can protect people when their information is out, is been breached. So.
The time of the
That's it. Thank you.
gentlelady is expired. The chair now recognizes the gentleman from Washington, Mr. Heck, for 5 minutes.
Thank you, Mr. Chairman. So I want to get at this issue of what do we do about data breaches, and I want to think outside the box a little bit. I'm reflecting back on the Equifax breach, and part of which I found incredibly galling, namely that the company essentially threw one person under the bus. I don't know if that was motivated by a liability limitation, but I thought it was exceedingly poor form. But it was also galling, frankly, because it suggested that something that was so mission critical was dependent on one single individual, which seems to be a systems issue. But I got to thinking about the gold standard that we have all around us in even more tragic circumstances, not that this one wasn't tragic, and that would be the National Transportation Safety Board, which is charged to go in after accidents of trains or planes and do the investigation. Why did this happen, and what can we do to prevent it in the future? And there's also a chemical safety board for chemical spills, oil platforms, and the like. That's their sole job. Go in and look at why this thing happened and what can be done to prevent it in the future. So I got to thinking, a computer network safety board, an entity, a federal government entity whose sole job would be to determine how did this come about and what is it that needs to happen in order to prevent it going forward. So just going down the line there, I'm interested in your reaction to that idea.
Which end are you starting at?
Yours, sir, because you were nodding the whole time I was talking.
Well, no, I mean, it's actually an idea that I've been toying with myself. I would say that the only problem that I see with it, serious, is that cybersecurity is really two components. There's the systems approach portion of management of the company, protocols in place, awareness of the issue, risk assessments, that sort of thing. And then there's the technical piece of, did you fail to patch? Was the intrusion detection system inadequate? That sort of thing. So as you went forward, you would want to do both. And the problem, which is very much mirrored in the NTSB, is that the former of those, the human system part, is a lot harder to evaluate with precision than the latter. The NTSB can say Part A failed, but they can't say that the company didn't inspect frequently enough, because frequently enough is a flexible standard that doesn't. But I like the idea generically.
But we have human error on the transportation front too.
Right.
I'm not understanding why you think the analogy breaks down.
I don't think the analogy breaks down. It's just that the way you phrased the question at least made me think that you were thinking only of the technical side of the problem.
No.
Then, so long as we're willing to accept that human error is human error and can't be eradicated from any human system,
Right.
I would follow you down this road.
Good.
Well, sir, I'm going to give you a different answer. I don't think we need another entity responsible for computer security. I think the problem right now is that there's overlapping authority that needs to be clarified. Both the FTC and the Consumer Finance Protection Bureau have responsibility for security standards, but it's not a mandatory standard, and that's part of the problem. I suggest in my testimony that that authority, which currently exists, should be strengthened. I also want to mention, and I mentioned this in the testimony, I was very concerned when I read the news reports that the acting director of the CFPB, Mr. Mulvaney, has apparently decided to discontinue the investigation of Equifax when his agency already had the authority to pursue the matter. Now, why this is of particular concern is not simply about, compensating the individuals for whatever harm they have suffered, but it's now almost 6 months since one of the greatest data breaches in U.S. history has occurred, and we still don't know who's responsible. I mean, that's actually a remarkable fact. It's as if we went through 9/11 and didn't know who was on those planes. I remember that day. And I almost can't believe that at this moment in time, we still don't know who's responsible for the Equifax attack. So I would say rather than create a new authority, we should make sure that current authorities should do their job. And the last thing that a current authority should do is drop an investigation that it already has the authority to pursue.
I'm virtually out of time. Sorry to the rest of the panelists. I'm sure that you had something meaningful to add as well.
Gentleman's time expired. The chair now recognizes a gentleman from Georgia, Mr. Loudermilk, for 5 minutes.
Thank you, Mr. Chairman. I appreciate the panel being here after spending nearly 30 years in the IT industry and a lot in data security. This is a critical balance that we have to strike here because, as I've heard in here stated several times, it's very difficult, and Congress cannot respond in the appropriate time frame for stringent regulatory stringent regulations for something that moves as fast as technology. It's impossible for us to keep up with it, and having a hard set federal standard that meets everything would be like the EPA trying to regulate the security exchanges. It's not going to, it just isn't going to fit in every situation. So our struggle is how do we ultimately protect the consumer? And as we've seen time and time again, as we have to continue to review regulations, especially when you're dealing with financial services, if you over-regulate, what happens is the businesses then are more concerned of meeting the legal standard of the regulation instead of actually doing what's best for the consumer. But yet, you have to have some type of guideline. And that's where I think our struggle is here. What is that balance? How do we get to that balance? And as Mr. Taylor said several times, no breaches are the same. I mean, they're very unique based on the platform, the diversity of systems, the type of industry in, or even the source of the breach. You know, and that's what we're struggling with a lot now is who's liable, and it's not, in the current system, it's not always those who actually that caused the data to be breached that are ultimately liable for the consumers and the cost that they're facing. So I think for me, it's looking for what is that stringent guideline or standard that can be flexible. And I think that's what I'm hearing from a lot of the panelists here is the flexibility, but one that is stringent enough that can go across the multiple platforms. Because what we're looking at now is totally something different than what our founders ever envisioned. Through federalism, you've got, states had banks. You know, through history, the state of Georgia, when I was in the state legislature, we regulated banks. Well, they regulate very few banks now because the federal government's doing it because they cross so many platforms and money is not transferred by Wells Fargo wagons anymore. It's transferred instantaneously through data networks, which brings in more people who with more liability and more chances for this to be disclosed. One of the issues that I've spoken about quite often coming from this background is basically a principle we had when I was in the military dealing with intelligence data was you don't have to secure what you don't have. In other words, don't keep a bunch of stuff. And one of my concerns that we have is in the government, we require so much data to either be reported to the government or to be held by companies that really you don't need to keep in an archive that makes us more vulnerable. Mr. Cooper, with the different standards across the different states, and I understand this, it's very difficult for businesses. I mean, even small businesses, my business, we worked in multiple states. It's very difficult for businesses to know what standard each state has. When it comes to personal identifiable information, do we have multiple definitions of that through states?
Yes, different states have different definitions of what type of personal information triggers a notification requirement. Perhaps more importantly, there are only a dozen or so states that have data security rules in the first place. And I think you put your finger on exactly what the difficulty or the art is and what you're trying to do here, which is how to establish a flexible security standard where that flexibility also scales up as time goes on, because as you point out, the types of threats that we're going to face 10 years from now are different than the ones that we face today, and a flexible standard should make sure that the requirements also ratchet up as we are aware of those threats.
Well, let me add another aspect into that, because one of the things we don't hear a lot about right now is, are we aggressively going after the bad guys? Are we pursuing that aspect? Okay, there's the prevention aspect, but one of the ways of preventing is also prosecuting it. Are we putting enough effort in actually going after the criminals who are creating these problems?
So I think it's a really important point to highlight that in these data breaches, there are always criminal acts, and making sure that law enforcement does have not just the direction that these are priorities, but also the resources and the institutional knowledge to be able to do the forensics that's required in order to catch them. It's very difficult, and there are different kinds of breaches, and we need to recognize that there are breaches that are from sophisticated actors, some nation-state linked, some not. There are also much less sophisticated activity that still have a significant impact on all the companies that we're talking about in every industry sector, because every industry is relying on data in some way.
The time of the gentleman has expired. The chair now recognizes the gentleman from Tennessee, Mr. Kustoff, for 5 minutes.
Thank you, Mr. Chairman, and I do thank the witnesses for appearing today at this very important hearing. Mr. Rosenzweig, if I can, we've talked about these disturbing cyber attacks that we've seen throughout the last several years. We've talked about Equifax this morning, which affected almost 145 million Americans. And of course, their data has likely been sold on the black web, on the dark web to somebody. With Equifax and with other breaches, with Target, with the Office of Personnel Management, information being sold throughout the internet, it's clear that indeed our financial institutions are clearly vulnerable to attacks. And as much as we look to do to prevent them, these perpetrators still look for weaknesses in firewalls and other data protection mechanisms. We talked today about a national standard or a federal standard. In your opinion, if Congress years ago had already enacted such a standard as you and some of the other witnesses had talked about today, do you think that these breaches still would have occurred? And if the answer is no, can you talk about how it should be structured or could be structured?
I think the answer is yes. The breaches still would have occurred. Maybe not the exact same sets of breaches, but data breach notification law is an after-the-fact amelioration of a harm that has already occurred. The existence of data breach notification laws in 48 states and throughout Europe and throughout the world has not stopped the prevalence of cybersecurity breaches. What is necessary or what is appropriate to try and implement to limit or reduce the amount of cybersecurity breaches, since of course they can't be eliminated altogether, is some form of primary standard setting that requires and addresses and advocates for people to raise their game, to bring up the nature of what they're doing so that they are more secure overall. That includes deploying firewalls and intrusion detection systems. That includes process management systems so that corporations have an awareness of and do risk assessments on their companies. Those sorts of steps are the primary way of fixing the cybersecurity. Data breach notification is about privacy, and it's about ameliorating the harm after it's occurred, but it's not a primary way of achieving cybersecurity. It's derivative.
Thank you very much. Ms. Bonham, as we look at banks and credit unions, I'm interested in how our financial institutions identify and address cyber attacks when they occur. And as the president of the Summit Credit Union, can you discuss the systems that your institution has in place to detect a data breach, or other credit unions, what systems they would have in place to detect a credit breach?
So we have, as Summit Credit Union and other financial institutions, we have data intrusion tests done on our systems all the time. And so we test our systems, we hire people to try to hack into our systems, and so that we can fix any type of vulnerabilities that we might have. In terms of how do we detect a breach by another entity that might be impacting our members, sometimes that comes from our members themselves who report a fraudulent charge, and we start to connect the dots and say, geez, this is interesting. It comes from similar places. So sometimes it's identified that way. Sometimes we get lists from Visa. Sometimes we read about it in the newspaper. Companies do not tend to be forthright, and especially merchants, with data breaches. And that leads also to this big time delay in us being able to notify people. Do we really want consumers to have to worry about looking at their information all the time in order to protect themselves from that? Probably not. We want, if we can get a heads up from a company that their systems have been compromised, that's a good indication for consumers to be able to say, oh, okay, now I'm going to look at this a little bit more closely. So we look at that from all different sources, and it's not the same. And from a loan fraudulent activity perspective, that we try to protect our members in many different ways by trying to cross-reference different lists and looking up things to make sure that information is consistent so that we are not issuing fraudulent loans.
Thank you. My time has expired. Thank you.
Time of the gentleman is expired. The chair now recognizes the gentle lady from New York, Ms. Tenney, for 5 minutes.
Thank you, Mr. Chairman, and thank you, panel, for this really important meeting. Obviously, this is a huge issue. A really unusual thing happened in my district recently. We had actually a bank robbery where somebody walked into the bank in a traditional way and reminded me of the old movie, Woody Allen movie, Take the Money and Run. They went into the bank with his soap gun. But this is interesting that now this is occurring in cyberspace. It's just like watching, a sports event from the comfort of your living room. You can now rob a bank and heist millions and billions of dollars just by cyber. And so I think what my biggest concern is, and obviously I wanted to start with Mr. Rosenzweig about a number of years ago, I attended a seminar before, it was right about the time New York State, and I'm a member from New York State, when the Department of Financial Services was being put together, and the discussion was now our institutions, our banking and financial institutions, our credit unions, are going to be asked to hand over their private information, which they so carefully secure, their information about their customers, obviously their lifeline, to the state of New York, and the concern over the protection and the ability of the taxpayers to protect this data. And so that's my concern, is that I think, we know banks and institutions, and we've heard, obviously Ms. Bonham and others talking about how important it is to protect theirs, but how at risk are we when we hand our data over to the state of New York, for example, and how do we prevent against them being hacked? We know that Congress and our institutions are hacked numerous times on a daily basis. Now, the taxpayers, how do we get around the cost and being able to protect that and still have a regulatory regime in place and the balance there? I don't know if you have an opinion on that.
That's a great question.
Mm-hmm.
Neither the federal government nor the state governments are immune from this problem.
Mm-hmm.
South Carolina had a very large breach of their driver's license system a few years ago. I'm aware of breaches in California and Illinois as well. I don't know of any in New York particularly, but I imagine they must have happened. And obviously the OPM breach was far more significant for me personally than the Equifax breach because I lost my fingerprints. There is no way to guarantee the security of state and federal databases any more than there is a way of guaranteeing the security of bank breaches. I think that the answer is much the same as with private entities, that state and local institutions and federal institutions need to be mandated, forced to up their game so that they give at least the best that they can give us.
No, thank you. I do worry because obviously Equifax was a major factor. It hurt our community in these major breaches. I'm just concerned that we go to from the private institution, which obviously has their most important asset is their customer, to have to give that information up to a government entity just for regulatory purposes, and we know that governments are not always so reliable. I might ask Ms. Sponham if you could just tell us a little bit about your viewpoint on dealing with the credit union situation, how we protect, especially you identified in your testimony, small credit unions and the risk that you've taken, and how you feel about turning your data over, dealing with your data when it comes to protecting your customers.
So we are very careful about who we turn our information over to, because we also know that, and why the hearing is taking place, is that other entities are not protecting data in the same way that we protect data. And so we do not like to turn over any information that is personal information about our members unless we are absolutely have to do that.
Thank you. One last thing, and just on the, if we could go to, I'd say Mr. Rosenzweig or whoever might have an opinion, what can we do to minimize this risk and exposure on the private sector in terms of what could we put in place in terms of a formation of a bill or a regulatory regime that would help us protect the customer, but also protect the asset, in the event that we do have to turn data over? I don't know if you have...
I would give you 2 quick points. Minimization data, a couple of people have said that. You can't be breached for that which you don't collect. And the second, which is a word that we haven't said at all in this hearing, is resiliency, which is plan for the failure. It will happen, and what we really don't have is a lot of good recovery systems.
No, I appreciate that, because I know you pointed out the obvious. I mean, it's great to have, to deal with the data breach later, but it's already, the damage has been done, and, the horse is already out of the barn. So I do appreciate it. I think preventing it is to me, and again, I thank you for your comments. I love that let's not give the information out, so in that case, it's not going to be secured. I still have many of my constituents who refuse to even have a bank account. They're still hiding it in the mattress because they're so afraid of data security. But thank you so much for the panel and for the chairman. I yield back. Thank you.
Gentlelady yields back. The chair now recognizes the gentleman from Kentucky, Mr. Barr, for 5 minutes.
Thank you, Mr. Chairman. Thank you to our witnesses for your testimony today. I'll start with Ms. Sponham. Thank you. I have heard from many of my credit unions that I represent in Central Kentucky about the data breach problem. And can you just tell us once again what the average cost is to replace a debit or credit card?
So anywhere between $3 and $5 per card, but that is actually the least expensive part of a data breach.
Because of the fraud monitoring that you have to engage with, addressing your member calls and actually helping them navigate the ramifications of the breach?
That is correct. So the actual talking with our members, talking through the breach with them, what they need to do to rectify the situation, to make them whole, but also the actual fraudulent charges themselves fall on the financial institution.
Right.
And so as we talk about the standards for other companies, really what is the incentive for companies to not protect their data, or to protect their data, if we are going to pay for all of the breaches, when you take
on all the responsibility. And yet financial institutions like credit unions and community banks, you're subject to the Graham-Leach-Bliley standards that don't apply to other sectors of the economy. Is that correct?
We are absolutely held to those standards, along with the reporting of any type of breaches.
So your testimony resonates with me because, as I said before, so many credit unions and community banks in the 6th District of Kentucky have told me that of all of the regulatory pressures that they face and the compliance costs that they deal with, this is one of their very top priorities in terms of additional cost, and ultimately, who bears that cost?
We bear all of the costs of data breaches, of if there is a fraudulent loan, any type of fraudulent activity, including wire transfers. We hold all of that responsibility.
But then beyond that, where's that cost passed along to?
Well, because we're owned by our members, it's really our members' money that we are spending in these fraudulent situations, and that's $1 million in 2017 that could have gone to other things that would have benefited our members.
So consumers, the members of the credit union or a customer of a community bank, they're the ones ultimately that pay for this in the form of higher fees or more expensive financial services.
They absolutely do, yeah.
Now let's move on to, that's the problem. Let's move on to the solution a little bit, and the proposed federal legislation to Mr. Taylor and also Mr. Cooper, if you would. There seems to be some tension in the recommendations a little bit in terms of the desire to create some certainty and some clarity in terms of what standards the merchant community or whoever has to comply with. But also there is also testimony here today about the need for flexible, scalable standards and technology neutral standards. We don't want to create a box so that we suppress innovation. Can you all help us as we craft this legislation reconcile that tension? Yes, we want flexibility. Yes, we want scalability. We want technology neutral. I take that recommendation seriously. But how can we, at the same time, provide for the merchant community that is responsible for adhering to those standards some clarity and legal certainty?
So I think we want it to be outcome focused. So I think the goal of a federal standard on security should be what steps, depending on the size of the entity, the type of personal information they have, the amount of personal information they have, what steps will be appropriate. And if we have the Federal Trade Commission and state attorney generals all enforcing the same law and the same standard, we'll get that consistency where it still allows for it to be scaled up or down depending on the type of entity or the emergence of new kinds of threats.
I would reiterate the point that you made earlier about the Gramm-Leach-Bliley Act and look at that as a model. And it does include notification standards, by the way. I think earlier someone said that it didn't, but it does. But the GLBA model is in fact one that focuses on the process, right? It's technology neutral. You need to think about risk. You need to adopt safeguards that address those risks.
And final question, Mr. Rosenweig. Should legislation deny a private right of action? Would a private right of action undermine consistent enforcement? And what should be the interface between litigation versus maybe a regulatory compliance defense or a standard compliance defense?
I'm a little agnostic on that. I tend to favor an administrative enforcement mechanism rather than the randomness of class action and litigation.
Anybody else on that?
Gentleman's time has expired. I'd like to thank our witnesses for their testimony today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witnesses to please respond as promptly as you are able. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion of the record. The hearing is adjourned.